but he had a very different trajectory. He, by the age of 5, was setting people's bed on fire,
Ooh.
attacking people with scissors and knives, and was so dangerous to his local school in Arkansas that the family shipped him to LA to live with an aunt because they couldn't handle him anymore in the school or in the home.
Hello and welcome to the Attorney Post, where we give you the inside scoop with top attorneys in their field. And now, here's our host, Justin West.
All right. Hello, everybody, and welcome back to the Attorney Post, where we discuss what's going on in various facets of the law with attorneys at the top of their game to help you navigate the various ins and outs of legal fields and jurisdictions. Because, as I always say, if you don't know your rights, you don't have any. Today, I'm very pleased to be joined by Thomas Cifarelli, who runs the eponymous law firm that bears his name. That is Cifarelli, the Cifarelli Law Firm out in, I believe, in Irvine, California. Thomas, how are you doing this morning or this afternoon?
Very well. How are you, Justin?
I am doing good. I guess it's just now afternoon for you. It's been afternoon for a couple hours for me, but that's okay. Well, before we begin, we're going to jump over, as always, and take a look at Tom's website. This is Cifarelli injurylaw.com. You should be able to see that right there. Again, award-winning California lawyers in practice since 1979. So your firm is I don't want to date anybody, but it's about as old as I am, which is good to see there. So the law firm is CifarelliInjuryLaw.com. That is their website. If you have a reason to consult them, that is 949-502-8600. Should get you in touch with them. And as always, we will have links to all of their information down below in the show notes. And again, they specialize in obviously injury law, but also a lot of stuff about child sexual abuse in general. And that's kind of what we're going to be talking about today. So at the top of the show, I did want to kind of give, I guess I would say, a trigger warning. I don't normally do that because we normally just talk about various facets of the law. But if you are a victim of sexual abuse and the conversation would be triggering to you, please just bear that in mind as you are watching this show. We won't be talking about anything too graphic, I don't think, but it is still the topic of the show today, so please be mindful. Before we do anything else, though, we are going to read from our sponsors. Our first sponsor today is Habanero Social. What if Google could send you free clients or customers every single month? With Habanero Social, it's not a fantasy, it's a reality. Habanero Social is the AI-powered platform that optimizes your Google business profile to attract more local customers effortlessly. From cranking out high-quality content to managing reviews and fine-tuning your local SEO, Habanero Social handles it all while you sit back and watch your business grow. 85% of searches happen in local searches happen in the Google Maps pack, so that's the place that you need to be to capture those clients. An optimized Google business profile doesn't just show up, it engages, it builds trust, increases clicks, and ultimately boosts your business. And Habanero Social is so confident that what they do will work for you that they offer a 3 times ROI guarantee. If you don't make at least 3 times more than you spend with them, they will refund your money or work for free to make it right. So stop wasting time on old school tactics. Habanero Social automates everything to help you rank higher, engage better, and drive more customers or clients to your business. Visit habanerosocial.com, and as always, we will have a link to them down below in the description. Our second sponsor today is Groove Funnels. Entrepreneurs and dream chasers, listen up. If you're running an online business, it doesn't mean you have to be drowning in subscriptions or wrestling with a messy tech stack. Groove is rolling out a jaw-dropping limited-time offer that allows you to run your entire operation. Think stunning websites, Groove pages, high-converting funnels, email campaigns, e-commerce stores, affiliate marketing, all of that stuff for an entire year for a one-time fee of $2.99. That's 1 month with one of the services that they are a competitor to, and yet they give you all the things that their competitors do. If you want to try out this offer right now, go to theattorneypost.com/groove. That's theattorneypost.com/groove. There's no credit card needed. You can actually try it out for 30 days for free. If you like it after 30 days, pay for the full year one time, use it as much as you want. And again, if you can't make it successful, then just leave it by the wayside. But please visit attorneypost.com. That's theattorneypost.com/groove to sign up today and learn more. All right, and let me unshare my screen here. There we go. All righty. So again, I have Tom with me today. Tom is a nationally recognized trial attorney. He's the founder of the Cifarelli law firm, again, the law firm that bears his name, where he represents survivors of sexual abuse and serious personal injury. For more than 3 decades, he's taken on some of the toughest cases in California, including those involving negligent schools, churches, youth organizations, and other institutions. His practice is rooted in a deep commitment to protecting the vulnerable and holding the powerful accountable. Known for his tough litigation and heartfelt client advocacy, Tom has secured substantial verdicts and settlements that bring real change. He's often sought after for his insight on institutional abuse and legal reform. And through every single case, Tom works to ensure that his survivors are heard, respected, and empowered to reclaim their lives. Now, that was a little bit of an intro there, but I'm sure it missed a lot of the core of who you are. So my first question to you, Tom, is just the standard. What did I miss? Tell me about Tom. Who are you? What do you do? What makes you tick?
Well, first of all, Justin, I think you covered a lot. Thank you for having me. It's a pleasure to be here. You said some really nice things. What I am, we are attorneys for survivors of catastrophic incidents. And oftentimes in my practice, those catastrophic incidents are child sexual abuse. But I also do a number of cases involving adults who might be sexually abused or sexually harassed in the workplace. I also have a number of cases involving privacy rights associated with child sexual abuse victims, and then another kind of collection of other cases involving catastrophic injury. But overwhelmingly, the vast majority of what we do is represent children in sexual abuse cases against schools, churches, athletic organizations, some of the entities you identified.
Gotcha. So, I mean, that sort of leads into my very next question, but I'm going to go ahead and ask it anyway. Give me a pitch for your firm, right? Tell me specifically where. I know you're located in California. Do you work only in California? And how do people find you, and why do they choose to work with your firm?
Sure. That's a fair question. So my firm, unlike many others where they practice sort of anything that comes in the door, even any injury case that comes in the door, we really have over the last 30 years developed a specialty in child sexual abuse cases and sexual abuse cases. And so we devote an enormous amount of time, human resources, and effort into each case we take. We don't take 10,000 cases. I'm not a television advertising attorney, not that there are not some good ones out there, but typically TV attorneys are advertising for anything under the sun, and they take all comers, and they have these enormous volume of calls for anything. We don't take everything and anything. We specialize in this area of law, and that's so that we can be very selective. And then when we do take a case, we can give it all the attention it requires. So typically, if a case comes in my office, there'll be myself and everyone or almost every one of the other lawyers working in my firm working on that case. There'll be a paralegal, there'll be a client advocate who will be in touch with the client on a more regular basis, who's a non-attorney, but who has a really great ability to sort of connect and be there on a day-to-day basis if the client needs something. For example, if a client requires a therapist or a counselor to talk to and was unable to get one, or has just been unable to find the right person for their need, our advocate will do that. So we really kind of bring the entire resource collection of the firm to each client. And for that reason, we're relatively selective. 9 out of the 10 cases I review, I turn down. Oftentimes, I'll refer them to another lawyer if it's just not the case we can handle. Meaning the 1 case out of 10 we do take, we really, really pour ourselves into the case in a way that, frankly, in my opinion, is unmatched in the state of California or the country.
Gotcha. Gotcha. That's awesome to hear that. So let me ask you this: what got you into law? I mean, this is winning results since 1979 is what it says on your thing. So
Yeah.
you guys have been in business for 45 years. So I'm assuming you're one of those people just knew you wanted to do law, or was this something that you stumbled into? And not only what got you into law, but what got you into this particular aspect of law? Have you always been doing injury work or catastrophic event work? And then what specifically led you from there into sexual abuse work?
Yeah. So that's a question with lots of subparts. So let me
Yeah.
try to answer it. First of all, I always knew from my first memory that I was going to be a lawyer. Um, in fact, my
You grew up
father,
watching Perry Mason reruns, or
not really, my dad was a lawyer.
okay,
My dad was actually a physician, and then he became an attorney, and he practiced medical malpractice law. And so it was him, not me. I don't know how old I look, but he was him who started his firm in 1979.
okay,
And then years, many, many years and decades later, when he was ready to retire, um, I said, "Hey, you know what? I get you're going to retire. I'm happy to jump in." Um, my brother was working with him at the time, Phil Cifarelli. So I said, you know what? I can come in. We can continue, but we can continue with my practice. I can continue in the firm with my practice. And by that point, I had been practicing law with firms, different firms up in LA for about 5 years. Right out of law school, I was very, very lucky to join some really wonderful firms with some great, great trial attorneys. The first firm I joined, I got to do catastrophic mass tort cases, environmental cases. Uh, and at that point, I was able to get an amazing amount of experience working against with some of the best lawyers in California as my bosses, my mentors, and against some of the biggest firms in the country. And so that was an incredibly unique opportunity where, and I don't want to get too far into the weeds, but where in the first year of practice, I was in probably 500 depositions. I know it
oh
sounds
wow,
crazy because there are only 300 days,
yeah,
360 days in a year, but there were times we were taking three depositions a day and or defending three or four or five depositions a day where we would just track it. And when you're young and you're hungry, you have no problem when they say, "Hey, we want to schedule depots on Saturdays and Sundays." I was a 25, 26-year-old guy. Bring it on. Let's do it. But the consequence was I was able to learn at an exponential rate because I was far and away the youngest lawyer, but I was working with these really seasoned folks in these really sophisticated catastrophic injury cases, and a lot of them were representing hundreds of plaintiffs. So I was able to get incredible amount of experience, and I did that for a while, and then I moved over to a different firm, and that's where I first got into handling my first child sexual abuse case. And
gotcha.
that's a whole story in of itself.
I was gonna say, how did that one come across your desk?
Yeah, great question. And it's a great story. So um I interviewed with my second boss, another extraordinary plaintiff's attorney. At the time, he was probably a 25-year attorney, very experienced, very seasoned. And he called me up and he said, "Hey, why don't you come in on Saturday and we can talk about a job I'd like you to consider." And so I showed up and we had a great interview, kind of a conversational interview about what I'd been doing and the kind of work he'd been doing. And just as the interview was about to end, um, he he said, "Well, you have the job if you want it, it's yours." And I knew I wanted it. And then just as I was walking out the door, he said, "Oh, wait a minute." And he grabbed a little manila envelope about as thin as two or three pieces of paper. And he says, "Hey, here, look, take a look at this. It's a potential case we're looking at, and let me know if it's anything. If it's something, run with it. But welcome aboard, and we'll see you on Monday." And so I was excited. I went home and I put that envelope on my desk, and I got to work on Monday. And I didn't look at that envelope right away. In fact, it took me about 4 or 5 days to look at it. And finally, I opened it up at home, and what it appeared to be was a police report. And it was a couple pages, like maybe 3 or 4 pages, and it had a lot of redactions, meaning a lot of information was blacked out. And so I kind of looked through it and read it and understood from reading it that it was a case of one child in school what appeared to be sexually assaulting another child. But all the names were redacted, and all the names, kids, adults, everything was redacted. And even some of the facts were redacted. But I read, and it was a sexual assault case, and I kept reading through the pages. And I put the paper down, and I went about my other casework, and I kept coming back to this document. And then at some point I realized, although it was redacted, what I was looking at was not just one police report of one incident, but it was two police reports, two separate incidents involving two separate victims, the second of which was our client, and the same perpetrator at the same school. And I realized, well, wait a minute. These are several months apart. And this looks like the school knew the first incident happened. How in the heck is that kid, the perpetrator, back in the school doing this again? And I went to my boss and I said, this is something I want to run with. And he kind of had the smile on his face and he said, go for it. Well, that case turned into a cross-country odyssey where I probably took 35 depositions in 3 states, reviewed 10,000 pages of records. And what turned out to be the facts of the case is that a boy grew up in Arkansas, in a little tiny town in Arkansas called Hope, Arkansas. And if that sounds familiar, it should, because that's the birthplace and the place where our former president, Bill Clinton, was born and raised.
Huh.
This other boy, this predator, was born and raised in Hope as well. But he had a very different trajectory. He, by the age of 5, was setting people's bed on fire, attacking people with scissors and knives, and was so dangerous to his local school in Arkansas that the family shipped him to LA to live with an aunt because they couldn't handle him anymore in the school or in the home. Well, he shows up in LA. He's put into his local public school, and the Arkansas school sent his file, but nobody at the local school in Southern California ever bothered to read it. In fact, they never even bothered to open the envelope, which was about that thick, filled with incidents. They instead just put him in a regular class where he started attacking other kids, including the 2 that were subject to the police report, the second of which was my client. So through discovery and through really aggressive litigation, we were able to uncover all this, and we took it to trial and got what was then in the 90s the largest jury verdict in LA County history for student-on-student violence, that was covered by the LA Times, the New York Times, a bunch of media. And so as a result of that, the next day I'm getting calls from all over California and the country for cases of sexual abuse.
Wow.
And that's how I got started in this particular area. And since then, it's been case after case.
So would you say that for you, I looked at your website earlier, I looked at, your attorney bio, and I see things on there, you know, premise liability, wrongful death, trucking accidents, car, your standard malpractice stuff. But would you say that the sexual abuse stuff really is kind of the hallmark of your particular practice in law, and that's really what you tend to focus on?
Absolutely. 100%.
Gotcha.
And
Gotcha.
I've certainly gone into other areas. And if they're fascinating cases where someone has been wronged, I bring with me the same sort of enthusiasm and passion. I've had cases involving horrific pharmacy mistakes. I've had cases involving horrific medical errors, operating when they shouldn't have operated on someone. I've had cases. One of my most noteworthy cases was a privacy rights and child sexual abuse case crossover, where a bunch of victims of child sexual abuse were, without their consent, publicly identified in a nationwide broadcast and publication. And so that case involved both privacy rights against the media company and First Amendment battles that went all the way up to the Supreme Court, as well as child sexual abuse issues. So, yes, the long answer to your question, that's a long answer to say yes. My primary area is child sexual abuse, but I've certainly looked and handled other cases, sometimes crossovers, sometimes separately.
Gotcha. Gotcha. That makes sense. Okay, so let's talk a little bit more about your career, and then we'll probably get into more of the specifics of handling these kinds of laws. I'm a firm believer that, you go up to bat enough, nobody bats 1,000. And I'm sure, Tom, that in your legal career, so it's getting really dark. There's like a storm rolling in over here. I'm gonna turn on my light for you guys.
Where are you?
I'm in Atchison, Kansas. So if Kansas is a
Oh,
big
okay.
rectangle with a bite out of the corner, we're right there. It's seven square miles and 12,000 people, but it's the birthplace of Amelia Earhart. That's our big claim to fame. So every
Nice.
year on her birthday, we have a big festival that draws tens and tens of thousands of people from all around the country, which is kind of neat. So anyway, something is rolling through. So I'm going to turn on my light because it all of a sudden got really dark in my office. Anyway, so I'm a firm believer that, you step up to bat enough, you're going to swing and you're going to miss sometimes. Failure is just a part of life, but a failure is only really a failure if you don't learn from it. So can you let my listeners know about some time in your legal profession, in your legal career, Tom, where you failed, where you experienced a setback, a case didn't go your way, a decision didn't happen, you forgot to fill out a form correctly, whatever it happens to be. But what's a time in your legal practice where you experienced failure, and what did you learn from it? And how do you carry that forward to make sure you're always giving the best care to your clients?
Absolutely. Failure. If I think it's Michael Jordan who said, I missed 10,000 shots. Nobody talks about the 10,000 shots I didn't make. They just talk about the ones I did. And you can't succeed without failure.
As Wayne Gretzky also said, you miss 100% of the shots you don't take. So
Yeah. But I don't know a lawyer, and me included, who hasn't had a case you poured your heart, soul into. Uh, you believed and you knew you were on the right side. And unfortunately, at the end of the day, for whatever reason, it just doesn't work the way it should. And once in a while, justice isn't served. And I certainly have had my share of failures. The one I think about from time to time is a child sexual abuse case. It was 25 plus years ago. And it was when the statute of limitations, that's the time limit within which a survivor of an injury, and statutes of limitations apply to all sorts of cases. It's the time limit you have to bring a lawsuit over your incident. In California, for example, right now, generally, if you get into, say, a car accident, you have a set period of time in which to file suit. And for a general personal injury, such that might happen in a car accident, that's a 2-year limit. Well, in child sexual abuse, the limit's a little different, and it's been evolving over the years. It's to my knowledge, it is the most frequently amended statute of limitations in the state of California, and probably the country, because of the ever-evolving thought on child sexual abuse and the ability of victims to come forward. Well, 25 or so years ago, I had a case when the statute was more limited, particularly against public schools. And I got a case that was one of the most tragic stories of abuse by a teacher in a public school. Never should have happened. The school knew about it. The school ignored the some warning signs and allowed a predator to continue to work in the school. And my client was one of maybe his last victim before he was finally arrested. But it was so long ago that the statutes at the time didn't reflect what we know now is the amount of time it sometimes takes victims, survivors of abuse to come forward. So back then the statute was such where she just, I knew it was an uphill battle on the timing, and she just didn't come in soon enough. She came in several years after the incidents, and I knew it would be an uphill battle, but I felt so strongly about the facts, we pursued it. And unfortunately, the court ultimately denied the case on timing. We took it up to the Court of Appeals, and I argued it myself. But unfortunately, the Court of Appeals agreed with the trial court. In fact, I think the first line, or one of the first lines of the Court of Appeals order was, as horrific as child abuse cases are in general, and the facts of this particular case are in particular, we are constrained by the limits of the law. And so it was to me, it was just heartbreaking. But it was just kind of the way things were a quarter of a century ago in that particular case at that particular time. So that to me is one. It hurt. I spent a lot of time and effort trying to help that young lady, and it was a rough conclusion to a tough case.
Yeah, absolutely. I've always found statute limitations, they feel very unfair sometimes, although I understand why they're there. And you have to have, in a world, in a society where we presume the innocence of the defendant, and they need to be able to mount a defense, calling up something from 35, 40, 50 years ago obviously would just be unfair. Like, I get it. But there are times, especially when it's just on the edge of a small window, that it feels very broken. But testing 1, 2.
Justin, you dropped for a minute, but I can hear you now.
Okay, good. My mic all of a sudden has a short in the wire or something. I don't know what the deal is. If I touch it the wrong way, it clicks in my ear really weird. So sorry about that. Anyway, we're doing it live, folks. It's just how it goes sometimes. You roll with the punches, and we're able to do this. It still baffles me that we're able to have these conversations, thousands of miles apart. So we can put up with a little bit of a technical inconvenience here and there. So anyway, yeah, statute of limitations is rough, but I do understand it. Well, so let me ask the flip side of that question then. Obviously, you had some great successes as well. Some of the biggest verdicts in the arena in which you are competing in your state. What would you say is one or two of the things that you've accomplished in your legal career, Tom, that you're most proud of?
Well, that's a question. There are a whole bunch of cases, and a lot of times I think of these cases as almost like children, like my children, and it's hard to pick one or two because I love and care about them all. A case we just finished within the last 6 months was one that stands out. It is what I believe and what our research and what the defense tells us is the largest single plaintiff child sexual abuse settlement in California history pre-trial, meaning we spared the client And I'm so thankful we didn't have to put her through a trial because she had been through enough. We spared her having to go to trial. We started the trial, and it was basically we were arguing what's called motions in limine. And we'd done all the work for it, but we were able to settle the case for $9.5 million cash paid to her before trial, before a verdict, and save her that pain of having to be examined and stand up there and talk about these things that happened to her in elementary school. So that's a case I'm extremely proud of, particularly given the outcome. I know, great outcome, wonderful, wonderful young lady who at the time of the abuse was about 10 years old, and at the time of the settlement was 19 years old. And so at the very beginning of her life, we're able to put her in a position where she can basically have and do and pursue anything she wants. And one of the great things is she's such a wonderful young lady. She's not going to just take the money and buy a house and a Lamborghini and ride off into the sunset. She actually is attending nursing school now
Oh, wow.
and wants to give back. Now she can take care of her family, but she wants to give back, and she's in nursing school, and she's holding down a job still while she's in nursing school. So really a fantastic lady who, as a result of a lot of hard work, and some good luck, because luck always counts. Luck is an important part of our business. Anyone who's in this business knows it's not all you. Luck is huge. So a lot of hard work, some good luck, and we were able to get her that result. So that was really important.
Absolutely. So let me ask you this. I mean, you mentioned wanting to avoid the hurdles of having her have to get up and testify and relive these moments. What are the biggest hurdles for survivors of sexual abuse in general? And how do you help minimize the harm of the litigation process?
Yeah. So glad you asked that question. Um, Sexual abuse lawsuits, sexual abuse, child sexual abuse is the most underreported crime in America. About 20 plus years ago, the Department of Education did a study that showed perhaps 10% of students in the public school system throughout the United States are at one time or another subject to sexual abuse or sexual harassment by an adult.
Mm.
Now that 10%, that number is in the millions. I can tell you millions of people don't come forward. The biggest hurdle is so many survivors rightfully are just unable to publicly come forward and disclose what happened. And frankly, that's the reason the statute of limitations being broadened and being so long is so important, because it's a legislative and state recognition that a child or a teenager who's been abused is not going to be able to oftentimes come forward right away.
Yeah.
It's only decades later in some cases where they can reflect and get the courage to be able to finally speak up. And sometimes it's a psychological issue where their memory is repressed because the incidents were so tragic. The incidents were so traumatic that the brain has a way of protecting oneself by repressing the memory. So it's not constantly on our minds. So repressed memory cases are ones where someone's victimized as a child, they don't come out and disclose it for years or decades later. So that is a significant hurdle to these cases. People sometimes aren't able to come forward, or if they do, it's many years later. And then I've had plenty of people come to me, clients come to me, prospective clients, maybe a spouse or a family member would encourage them once they learned. They'd encourage them to come forward. They introduce them to me, and I talk to them, and they tell me, listen, I know what happened was wrong. I know the institution or the entity should be held responsible. I don't want to disclose this. It's too painful. I don't want it to disrupt my life. I don't want my wife to know or my children to know, or sometimes I don't want my parents to know, depending on the circumstances of the survivor. And so I've had a few clients come forward and then put the brakes on because they just couldn't go through with that public sort of participation in a lawsuit. And what I always tell them is something I always do. And and I always tell clients, and I always emphasize to young lawyers and to lawyers of all kinds, the importance, the absolute critical importance of pursuing these cases anonymously on behalf of the victims. So you probably we're all familiar, and you've probably heard of Jane Doe cases. These are all Jane Doe or John Doe cases. 30, 40 years ago, they weren't. Sometimes the courts didn't allow you 34 years ago to file as a John or a Jane Doe. And way back when, sometimes the schools or the defendants would, use that as a shield. Well, your client doesn't want to come forward. These are scurrilous allegations. She doesn't want to be part of a lawsuit with these allegations, does she or does he? But luckily, the legislature in California and through most of the country and the case law has protected victims and allowed them to come forward anonymously. So now it's commonplace. And I always remind my clients, it's commonplace to file as a Jane Doe or a John Doe so that their identities are protected, and to make sure that during the lawsuit, steps are taken to maintain their confidentiality and the confidentiality of their therapy records, their school records for the life of the case, so that the client, the survivor knows, the victim of abuse knows that I can come forward now and be protected.
When you're pursuing a case anonymously, I guess one question I actually have, is just out of curiosity, is how does that work for the defense? What do they know? What do they not know? Or do they know everything, but they simply have to refer to the plaintiff as Jane or John Doe? And then what are the big challenges?
Yeah, that's it. They know they're allowed to get the identity, but they have to refer to them in any public record or public filing as Jane or John Doe. But in the context of the litigation, of course, they're given all their identifying information, and that's only fair because they need to know, okay, did this person actually attend our school? Did this person actually sign into our hospital? Was this a patient of ours? Was this a participant in our church or in our sports league? So that's only fair that they, in the protected environment of the lawsuit, be able to know the identity. And so that's something that's common inside the lawsuit. But anything filed publicly or any public statements protect the victim such that they're only identified by a Jane or a John Doe. And there was a second part to your question. Remind me what the second part was.
Just the challenges that you face when you're bringing that. But I think more or less you kind of answered it. Like generally speaking, you're not going to have a whole lot in the way of challenges other than getting the person comfortable with being there and presenting whatever needs to be presented, I would assume. So let me ask a different question instead. You also mentioned repressed memories, and I find that a fascinating realm. How often do you get pushback on that? Well, this is a made up memory, and how do you prove a case, especially if it's years old and it's based on a repressed memory? Is it the preponderance of evidence, multiple claims? What are the challenges when dealing with repressed memory?
Well, in the arena of child sexual abuse, repressed memory is so well recognized and so common that the statute of limitations actually provides for victims who are suffering from repressed memory to have an additional period of time. So it's a well-known phenomenon among child sexual abuse victims. With that, repressed memory cases require a mental health practitioner to interview the victim and to then attest to the fact that they believe, based upon their interview, that this is a victim of childhood sexual abuse. So that's one initial hurdle. And then as far as proving liability on behalf of the defense, I have always repeated a mantra that I learned a long time ago just from practice. And that is this: I've never yet met the first victim. I've been doing these cases since 1994. In all those years, 31 years, these particular types of cases, I have never, ever represented the first victim of a particular abuser. These perpetrators are serial perpetrators. They have a history. And so when I take these cases and I dig into the discovery and investigate, when I start investigating these cases, I have always found a history of prior victims that the defendant, whether it be a school, a church, a youth group, a hospital, that the defendant knew about or should have known about because the records were there. The complaints were there. I've had plenty of cases where you get a personnel file of an employer, or excuse me, an employee's personnel file, and you look into the personnel file once you fight that battle with the defense, and they always try to prevent you from getting at it. But you get the personnel file or the student file of a student perpetrator, and you discover, oh, look, a year before they did this to someone else. Oh, here, 3 years before there was a parental complaint. Oh, there wasn't just one parental complaint, there were a dozen parental complaints about other victims. Oh, there were other patients who complained about this doctor and nothing happened. So that is something that helps establish the validity of a case such that a defendant won't get a lot of traction if they try to say, well, it's a repressed memory case, they're just making it up. And one other point, there's also been a lot of studies. And of course, there are exceptions to every rule, but there have been a lot of what we call white paper studies, peer-reviewed studies in medical journals, psychological journals that have proven that victims of childhood sexual abuse overwhelmingly don't lie about being victimized. What they tend to lie about is falsely denying they were abused. So they don't make it up and say, oh yeah, I'm a victim too. Who would? Who would subject themselves to that sort of incident and the attacks on their memory, on their behavior? What's much more common, particularly among male victims, but male and female, is to deny it. I had a case I will never forget, where a mother who was a newspaper reporter, and she had covered one of my prior cases. And after the case was over, she called my office and she made an appointment. She said, "Can I speak to you about something personal?" I said, "Sure, come on in." So she came in and she proceeded to tell me that she suspected her 15-year-old daughter was being sexually abused by her 40-year-old basketball coach in high school, but that the daughter denied it and said the mother was crazy for even thinking of such a thing. And the mom said to me, I hear her on the phone and she tells me she's on the phone with her girlfriend, but then I check the phone bill and it's not the girlfriend's number. It's some number I don't recognize. And when I try calling it, no one answers. I just have this weird suspicion. And sometimes the coach drops her off late at night and she says, "Oh, he's just dropped me off from practice." And my daughter says I'm crazy and that's so disgusting. How could I ever think about that? In this particular case, the coach had a son who was in the same grade as the girl, the victim. And the girl denied it. And I said, I'm happy to meet with your daughter. Bring her in. And so she made an appointment. She brought their daughter in, some days later. I sat alone with the daughter, and the daughter told me the same. Denied it, was convincing, and said, her mom's overprotective, her mom's wrong, it's disgusting, she would never do such a thing. I said, okay, I know and I understand, and if you ever want to talk about something, I'm here. And so then I told the mom privately, I said, look, in my gut, I think you're right, but we can't do anything if everyone involved is denying it, including your daughter, who's the alleged victim, and your daughter's calling you crazy, and there's no other witnesses, there's no evidence to support it. And so she just refused to say anything, and they left my office. Well, 8 months later, I get a call from the same mom, and she calls me panicked, crying. And she's in that state because her daughter, while working as a checkout girl at a grocery store, was attacked, physically attacked by the coach because she tried to break up with him. And he was stalking. Now it had become a stalking relationship where he showed up at her work, attacked her. He called the police, and that's when the daughter finally revealed that not only had he been abusing her for a year, but he threatened her. If she stopped, he would kill himself, then he would kill her, he would kill his family, her family. It was just a disastrous set of facts. But she had been, for obvious reasons, her own concerns, threats, she had been keeping this a secret. This is unfortunately what can happen. But luckily, justice was served. So the police arrested him. He ultimately confessed to everything, and she was able to come forward and pursue a case.
You'd said that you thought that sexual abuse, particularly child sexual abuse, is probably the most underreported crime. Who do you think, and this is more of an opinion question maybe, but who do you think is the biggest offender? Would you think it's the public schools? So in full disclosure, I'm Catholic, and so I'm subject to all the jokes about Catholic priests. Obviously, it happens. I'm in Boy Scouts, or rather, my boys are in Boy Scouts. I'm very aware that they've had issues recently as well. So I have multiple areas I've overlapped where I've definitely in that space, and steps have been taken. The Catholic Church in the United States now has a sexual abuse training program called Virtus that they put people through. The Boy Scouts does the same thing. They have youth protection that you have to go through. Is there something like that at the school level? And so I guess I'm asking two different questions at the same time, maybe even three different questions at the same time. Let me ask this question first then. What do you think is the single largest source of sexual offense, and what are some of the ones that would be most surprising people might not think about?
So child predators, perpetrators of sexual abuse, pedophiles, they go where they can find victims.
Mm-hmm.
It's that simple. Where do you find children in mass numbers? Schools, churches, youth sports. Those are the big three: schools, churches, youth sports. Youth, and when I say youth sports, I mean youth groups. Boy Scouts would be one of them. All the youth sports organizations you can mention, they've all had horrific incidents. I've represented dozens of clients against youth sports organizations throughout the country. But perpetrators go where they can find victims, just like a single person might go to a singles bar to find a date,
Mm-hmm.
or a single person might go to a dating app in the year 2025 to find a date, because that's where they are. That's where you find an appropriate date. Well, pedophiles go where they can find not dates, they go where they can find victims.
Yeah.
And where can they find them? Well, schools are in the business of young people. So they go and they become teachers. Churches deal with youth groups, children. In the Catholic Church, I'm Catholic too. And what do we have in every Catholic church? We have altar boys.
Mm-hmm.
And in many churches throughout the country, even to this day, with all the history of child abuse in the Catholic Church, and not just the Catholic Church, in all churches, there is a reverence among the community for the church leaders, for the priests, the pastors. In clerical society, in a church-oriented society, the churchgoers are going to literally and figuratively worship the priests and the pastors and so forth. And so they're going to teach their children, do what Father so-and-so says, do what Pastor so-and-so says.
Yeah.
And this is the living embodiment, the human embodiment of Christ or of God. So you have to be a good Catholic, be a good child. And so it sets up an organizational system where children can be abused. What do we tell our kids when we drop them off to complete strangers in the morning at school? Complete strangers. What do we say? Do what the teacher says. Listen to your teacher, right? What parent hasn't dropped off their kid in the first day of school and said, okay, have a good day, be a good student, right? And that means do what your teacher says. Listen to your teacher, ask questions, ask for help if you need help. Well, that should be what we do. Unfortunately, you have predators who look to find victims, and those are the organizations they look to find. Now, as a result of lawsuits, and this is one of the great benefits of what we do, the benefits of bringing lawsuits to compensate injured people is twofold. Number one, you compensate the injured person. Number two, if you're doing it right, you create institutional change. The Catholic Church, as a result of the thousands of lawsuits throughout the United States, has implemented institutional change, child abuse prevention, hotlines, things of that nature to prevent this from happening. The schools, the school districts, at this point, they have child abuse programs. They have safety code of ethics, code of conduct, teacher-student codes of conduct. As a result of child sexual abuse issues, where now we have rules. Teachers aren't supposed to be alone with kids. Teachers aren't supposed to drive kids in their car. Teachers aren't supposed to have kids at their homes. Teachers aren't supposed to do the things that are part of the grooming process of pedophiles, right? Giving gifts, giving special treatment, giving money, all the things that pedophiles do to create a trusting relationship with a child who may be particularly susceptible because he or she comes from a broken home, or her family is financially stressed, or he or she doesn't have a parent. That child is looking for the help that these predators then use to groom them, to create a relationship of trust such that they then push it beyond to abuse. And then the trust comes into play where they say, let's keep this a secret. You don't want anyone to know about this because then I won't be able to take care of you. And so that's kind of how it happens. So luckily, the secondary benefit of these lawsuits are we've created rules now in these institutions that should guard against it.
Are there any institutions you're aware of that haven't adopted any kind of a standard, or that haven't adopted what you think is a sufficient standard?
Sometimes you come into particular schools and they haven't quite caught up to the larger schools in the country that have made the changes. Sometimes you come into hospitals. You asked, where might people be surprised this happens? Medical care settings, healthcare settings, hospitals. You would be shocked to know the number of cases we see where there's a nurse abusing patients, sometimes even a doctor abusing patients. I had a case once where it was a surgeon right before the patient would go under anesthesia. Think about how evil that is. the surgeon would have one-on-one time where a good surgeon might reassure the patient, right?
Yeah.
If you've ever had a medical procedure, the doctor will come in and you love that, right? As a patient, you want to have the time with your doctor where he tells you everything's going to be okay. Here's what we're going to do, and everything's going to be fine. And here's how we're going to approach it. And we're looking for a great outcome. Well, I've had cases where one particular case, the surgeon taking that alone time would use that time to molest the patient. And the patient, I mean, imagine how horrific a circumstance this is, where the patient's already scared about the upcoming surgery that's moments away. And then the person you're entrusting your life to comes in and does that. You have the fear of the surgery plus the shock of the abuse and then the anesthesia. And this particular doctor was doing it because he was hoping
that it would be written off as an effect of the anesthesia?
Exactly. That it would be written off, forgotten. Oh, I must have been dreaming it because next thing I know, I woke up in the operating room. I must have dreamt it. And so that was a case where we came forward, and because the case got a lot of publicity, what we found is suddenly patient after patient after patient saw the publicity, came forward and said, hey, same thing happened to me with the same doctor.
Yeah.
I wasn't imagining it. I thought I was for all these years. I thought that was just my imagination, that he came in and did this to me, or he came in and did that. I didn't believe it was real until I saw this on TV. It was real. So that was literally a case where one case begat 10 cases, and there were probably another 50 out there.
Yeah.
Because this particular doctor had been practicing for 30 years.
What role do you think media exposure plays in these cases? And how do you balance media exposure, again, with client privacy? I'm assuming any journalist worth their salt knows how to respect John Doe, Jane Doe, but I guess tell me about that.
Yeah, that's a really important point. That's a very important point. First and foremost, anytime you have a child sexual abuse case, you have this intersection, this crossroads where you have the publicity of abuse, hoping to alert other victims, coming into the path of the privacy of the victims. And there's going to be a collision course. Now, when that collision happens, you always have to come out on the side of privacy. Privacy always prevails. The proper journalist, as you said, a journalist worth his salt, will always protect the privacy of the victim. And I've had litigation, MG versus Time Warner, a published decision by the a published decision by the California Supreme Court, MG versus Time Warner, established a child sexual abuse victim's right to privacy, even when the case is publicly covered and there's public prosecution. The victim has a right to privacy. And so it's super important that you get publicity generally about a perpetrator committing acts against victims, kids, but the identity of the kids is irrelevant. You don't need to know it was little Johnny Smith or Susie Johnson who was the victim. That's irrelevant. What the public needs to know is that the perpetrator and his or her name, that perpetrator was out there abusing kids in this circumstance. And so if you are one of the kids, or if your child or a loved one is one of the kids who went to that school, who played in that league, who attended that hospital or that institution, they should be aware that there are other victims. And that this perpetrator, let's identify the perpetrator, because he's a convicted felon now. He's out there and he didn't just victimize one or two or three. He may have victimized hundreds or even thousands.
So what does the interplay look like then? You wouldn't do any kind of publicity before the case was decided. I'm trying to think how I want to phrase this to make it make sense in the best possible way, most succinct way possible. I guess, A, how do you balance the publicity with potentials for appeals? Is there ever a potential for appeal, or is it once they're convicted, they've admitted and it's just over? And then what happens when people raise their hand and say, yeah, that happened to me as well? Is that a whole nother round of different lawsuits? And who is that targeted at? I mean, I'm sure in one sense it's targeted at the perpetrator, but it's usually going to be targeted, I would assume, at the institution.
Yeah, so it could be both. First of all, I'm a believer in everyone's constitutional right to a defense. So no one is guilty until they're convicted in
Hmm.
court, or they plead guilty and they're convicted, either convicted by jury, convicted by a plea. But once they're convicted, and certainly, yes, they have a right to appeal. But once they're convicted, then you have a convicted criminal, you have someone convicted of abuse. Then the question becomes, is this criminal case for which this perpetrator was convicted, is this the only case? Or, which is much more common, were there other victims out there? And more often than not, as I said, I've never met the first victim. There
Yeah.
are. And so when they hear the publicity related to the conviction, then you often have other victims come forward. So I try to, because of my sensitivity to the privacy rights of my clients, of my survivors, I'm not a huge practitioner of constant press releases and news media attention. That doesn't serve the victim. Um, Lawyers sometimes like to do press conferences, and there's a place for press conferences, certainly after a lawsuit. There's certainly a place for press conferences. But to protect the client while the lawsuit is going, I generally tend to avoid any sort of press that's going to subject my client to disclosure they don't want. Now,
Yeah.
sometimes the victim of abuse might want to come forward, and there are certainly victims of abuse, survivors of child sexual abuse, who come forward and are heroic, and they stand up and say, look, this happened to me, and this happened to a lot of people out there. And every one of them should come forward and not be shamed into silence, because this isn't your fault. This was
Yeah.
the fault of the perpetrator or of the institution that employed him. And as we touched on earlier, these incidents don't happen in an alley.
Hmm.
They don't happen at a random park somewhere where a predator will grab a kid. I mean, sure, those incidents can happen, but those are far more rare. Where it happens is where an institution puts kids in the orbit of a predator, and the institution fails, or the organization fails to notice the red flags that were raised by the perpetrator through prior complaints, through his or her conduct. Red flags of spending too much time with these kids, giving gifts, inappropriate comments or behavior where adults or other people in charge see it and ignore it. In the case I told you about, where the 15-year-old girl denied it, and then
Yeah.
the 40-year-old coach attacked her, when we got into the litigation and dug deep, we found that the school principal had seen them out at a restaurant together. The 40-year-old coach and my 15-year-old client at a restaurant alone at 9:30 at night, and didn't do a thing about it.
Huh.
6 months before the arrest, while they were in the midst of having this abusive situation where this coach was abusing this 15-year-old girl, the principal saw it, didn't do a thing, ignored it. Saw it, looked at them, looked away, walked out.
Hmm.
Went to the coach, not the parent, went to the coach the next day and asked a simple question: is everything okay? And of course, what'd the coach say? Oh,
Sure,
of
of
course,
course.
everything's great. Sure. I was just, she's been having a hard time with the certain move. I wanted to give her some special attention. And she's been really insecure about her play. I wanted to give her special attention. Oh, okay, no problem. Sounds good. Yeah, and I'm gonna give her some extra playing time. And the principal never did a thing about it. And that perpetrator went on to abuse that girl for 6 more months and ultimately attacked her at her job.
Wow. What do you think? what institutions most often get wrong when it comes to dealing with abuse allegations? And not just allegations, but noticing. I mean, obviously, sometimes they're just dropping the ball and not communicating. What are the steps they should be taking, and what patterns are you seeing in the way that some institutions cover up things or mishandle allegations?
Well, thankfully nowadays, cover up still happens, but it's not as common as it was. What they get wrong is they ignore the warning signs. They don't take the warning signs seriously. What they should be doing, in my opinion, is they should, the second they have a warning, they should remove the perpetrator from the environment. Not the child, remove the perpetrator. Because if you remove the child, what's the problem? You still have a perpetrator there, and he'll
Mhm.
just turn to another victim. So that doesn't solve anything.
No.
Yeah, you may have protected the kid, but now you still have a shark out there looking for the next meal, right? That perpetrator is looking, who am I going to get next?
Yeah.
The way you do it, in my opinion, is you remove the perpetrator from the circumstance, you report it immediately to law enforcement. And a lot of these adults in these schools and these organizations are mandatory reporters. The law requires them, if they suspect potential abuse, to report it to Child Protective Services, to the police, and then you let the police conduct their investigation. And more often than not, police do a wonderful job and they will get to the bottom of it and they will uncover the crime. But so often, unfortunately, you don't have that. You have schools, you have institutions, you have hospitals, you have organizations who don't want to get the police involved for whatever reason. Oh, it'll look bad. I don't want I don't want to get that kind of attention. It'll make me, as the administrator in charge or as the head of the organization, then I'll look like I failed. And then you get the sweeping under the rug. Let's bring the perpetrator in. Let me give him a strict warning. And they bring him in, and sometimes they'll write him up. You were warned never to touch these kids or never to engage in this sort of behavior, and you promised us you wouldn't, and we're going to put this in your file. Now go be a good boy. Go don't do this again. Well, guess what happens? They do it again and again and again. So
Do you
do we have everything you need?
do you find that juries are generally sympathetic to survivors of abuse, or do you think that there's still like a bias or a skepticism in the courtroom? And how do you deal with like a defense attorney, or even an institution that tries to smear or discredit your client?
Well, two questions. So I think jurors generally get it right. I think people get it right. I think if a juror hears the real facts, the full facts, they get it right. Sometimes in jury selection, the jurors who are most sensitive and most prone to get it right are removed because they have big hearts, and maybe they'll say something like, "Oh, this is so upsetting. I don't know if I could be fair. I would just want to find for the victim." And then so you might be left on a jury with a group of jurors who may seem um, a little more difficult to convince and a little more skeptical. But human beings, I've always believed human beings generally get it right. Human beings have hearts, they have human hearts. And so if you tell the right story, the true story, if you tell the story that should be told, you convey what happened to your client correctly, jurors will get it right most of the time. There are always exceptions. They'll get it right. Now, defense lawyers, the best defense lawyers, there are two types. There are some that say, "Oh, it's all a lie. It's all made up." I don't think those lawyers have a lot of credibility.
Yeah.
I think the better lawyers, the better defense lawyers are the ones who are honest. I think better lawyers, whatever side you're on, if you're just honest and straight and you deal with the situation as it exists, you don't try to say up is down and down is up. You say, "Look, this is a horrible thing that happened. It should have never happened, and we regret it." And you try to You try to argue about the reasonableness of what should happen. The reasonableness, what's reasonably fair for compensation to this particular victim or survivor. That to me is the most effective approach because it shows that you're being honest and fair and human. The
Yeah.
people who just say, "Oh, this is all a lie," and they don't deserve anything. There are a lot of lawyers out there like that. You see them when there are car accident cases. You see them when there are medical cases. You see them in these sorts of cases. But to me, that's the wrong way to approach it. It's just not a human way. Ultimately, we're human beings, and if you're doing it right, frankly, if you're a lawyer for an institution and you know this person is a real survivor, was victimized, and your institution dropped the ball, you shouldn't get that far. You should be coming forward with your client saying, "Look, we missed it. We screwed up. We want to do what's right, what's fair. What's fair to your client? Let's do that." That's what should happen. And I'll give credit. There are a lot of defendants out there. You see it in these mass cases who are trying to do what's fair, but so many more don't. So many more, they fight the cases, they deny it, and hopefully they ultimately get or will get taught a lesson about justice.
Yeah, no, 100%. Let me lighten this up just a little bit. Who is your favorite pop culture attorney? Your
Pop,
favorite,
pop
or
culture. You mean a fictitious lawyer?
it could, I mean, it could be like an actual attorney. Somebody the other day said Johnny Cochran, but who's
Yeah.
your favorite fictitious lawyer?
No, I knew Johnny. Johnny was a fine lawyer. My favorite is Jerry Spence, legendary Wyoming lawyer, Jerry Spence. As far as I'm concerned, the best lawyer, best trial lawyer who ever lived. Uh, I read all his books as a young lawyer in the 90s. I read every book. How to Argue and Win. His book was, just extraordinary. And then he had other books. I think one of them, he talked about an invasion of privacy case that he handled. It's the Silkwood case. I think he's head and shoulders the best lawyer there ever was in the trials sphere. He's still alive. Hopefully he's doing well out there in Wyoming, but he's number one in my book and was a big inspiration early in my career.
Okay, that's actually a new name for me. I'm not familiar with Jerry, but I'm looking at it right now, and yeah, he's still practicing. And he sure looks Wyoming, I will say. He's got the fringed leather, and
I believe Jerry is close to 100. I think he's in his late 90s at this point.
there's Jerry right there for those watching at home. If you want to see
That's
the
Jerry.
SpenceLawyers.com. So
Yeah.
free shout out to them, not affiliated with this particular episode at all. But since you brought it up, I thought that was fascinating, and it's always neat to learn something new. Well, Tom, I really appreciate you taking the time to talk about this serious issue with me today. I'm afraid that this is one of those episodes that YouTube is just going to like shadow ban because of the topic that we talk about, but hopefully it'll get out to people that need to hear it, need to see it. Here in a minute, I'm going to ask you my 3 closing questions. And I'll give those to you right now just so you can percolate on them for a minute. But I do appreciate the time that you've given us today. So question number 1 will be, if I gave you a magic wand and you could change one thing about your firm, what would you change and why? Number 2 is, if you can go back in time, meet young Tom and give him some advice fresh out of maybe law school, what advice would you give yourself and why? Other than the obvious, there's this thing called Bitcoin. When it comes out, buy a whole bunch of it and hold it to 100K, right? And then number 3, if I gave you my magic pen and with this pen you could strike a law from the books, add a new law or edit a law, what would you strike, add, or edit, and why? While you're percolating on that, we are going to jump back over and take another look at your website. I am talking again with Thomas Cifarelli of the eponymous law firm that bears his name, Cifarelli Law. This is his website. That is CifarelliInjuryLaw.com. If you are a victim, particularly of sexual abuse, particularly in the state of California, do you work beyond California? I think I started to ask that question earlier. I don't remember if I got the answer.
I handle cases with local counsel throughout the state, throughout the United States,
Okay.
with local counsel. For example, if I have a case in Florida, I'll have a Florida lawyer with me. If I have a case in Texas, Texas lawyer, and so forth. Most of overwhelming majority of what we do is throughout the state of California.
Okay, that makes sense. But yeah, so if you know somebody that has been a victim of sexual abuse, get them help in some way or another. And obviously, it sounds like Tom would be a really good resource for them. So again, we'll have all of his information down below in the show notes. We're going to read from our last sponsor really quickly, and that sponsor is, we were talking about news stuff earlier, Rank with News. Where is my read here for them? If there is a guaranteed way to get your law firm or your business featured regularly in major publications like Yahoo News and Bloomberg, Reuters, AP News, and more, and have those articles ranking locally, globally, nationally, sometimes in under 8 hours for major competitive keywords that people are actually searching for, what else would you need to know? Rank with News is simply the most powerful way to hit page one in under 2 weeks safely, organically, and permanently. It's like guaranteed SEO or search engine optimization on steroids, ranking quickly and sticking long term. If you're tired of poor visibility for your business, visit rankwithnews.com to learn more and book a time to speak with a specialist about featuring your firm or your business in major national 8-figure traffic sites that can launch you to page one of Google in a matter of hours and help you dominate your local marketplace. Get media exposure, rank higher in Google, build credibility, and win more customers and clients with rankwithnews.com. And again, we'll have notes and links to our sponsors down below as well. So, all right, Tom, I give you a magic wand. And with this magic wand, you can change something about your firm, something that you just would like to see different. What would you change about your firm?
I would give us the ability to take on every single case, every call we get. We just, unfortunately, we can't,
Yeah.
for practicalities, but I would love to be able to accept everyone who calls because there's so many people who are so impacted and need help, but one firm can't do it all. So that would be one thing I'd change if I had a magic wand. We try really hard.
That's a pretty straightforward answer, and that's, I guess, the kind of answer I would exactly expect from you. So that definitely makes sense. Okay, so question number two. We go back in time and you meet young Tom, and without breaking the space-time continuum, you're able to whisper just a couple of words of wisdom into your ear, a couple pieces of advice. What would you tell young Tom?
Take the foot off the gas once in a while. Enjoy life. Passes fast. That's what I tell him. I'm a type A squared,
Okay.
and I've always been. In fact, this is the calm, mellow Tom. The Tom at 25 was a blue flame. The hottest part of the flame is a blue flame.
Mhm.
The Tom at 25, there's nothing I wouldn't do, couldn't do. As I said at the beginning, okay, you want to do depots 7 days a week? We'll do depots 7 days a week. Let's go.
Yeah.
So I
No,
tell them to ease up and just enjoy life a little bit, which
stop
I'm
it.
trying to do now.
There you go. That's good advice for anyone out there. Just
Yes.
stop and smell the roses. All right, number three, I gave you my magical. This one actually is a pencil. It's just a pink Bic number two, 7 millimeter, 0.7 millimeter pencil. But this pencil seems to have magical abilities in that it can strike a law from the books, add a new law, or edit a law. There's only enough lead and only enough eraser for one change. So what change are you going to make and why?
Eliminate all statute of limitations, period, for certain cases, including victims of child sexual abuse.
I
Period.
kind of
Gone.
sus- I kind of suspected that was going to be your answer. I almost called it beforehand, but I didn't want to. I didn't want to shade or what's the word, influence where you were going to go with that. But that makes perfect sense given our conversation already. Well, Tom, thank you again very much for taking the time to talk with me and my listeners today. I do always like to let my guests have the final word. Are there any last thoughts or parting words of wisdom you'd like to leave our listeners with?
Yeah, I think if you're fortunate enough to be a lawyer and to represent people who come to you broken, suffering from the wrongdoing of someone else, take your job seriously and fight for their rights, fight to make them whole with every ounce of energy and resources you can muster.
Hmm.
'Cause in the end, we're doing justice. And how great, how lucky are we to do justice every day? We
Yeah.
get to get up every day and do justice. We are very privileged.
That makes sense. I like that. Well, again, thank you very much for taking the time to talk with me, Tom. This has been The Attorney Post. I've been talking with Tom Cifarelli, who runs the eponymous law firm that bears his name, Cifarelli Law. As always, we will have a link in the description to his website. And if you need him, please feel free to reach out to him. As always, though this podcast does deal with a whole host of legal topics, this podcast does not constitute legal advice. And if you have a legal issue, you should always seek the advice of a competent attorney in your area who focuses on the matter that you need help with. Now, obviously, especially if you live in California, but even if you live abroad and you're having a sexual abuse issue, please contact a lawyer in your area who can help you. But it sounds like Tom would be, and his firm, a great resource or at least a start point, and they can get you pointed in the right direction if they can't help you. But always know what your rights are. Always talk to an attorney so that you can get your rights taken care of. As far as the podcast goes, if you're listening to us on Apple, Stitcher, Spotify, or any of those auditory repositories, please like, subscribe, share, rate, review, whatever they allow you to do there. If you're on YouTube, obviously subscribe as well. But the most important thing you can do, especially with this particular episode, is share it with someone who needs to hear this information. YouTube very famously will suppress content that talks about sexual abuse, pedophilia. Those are all words that we've used in this conversation today. So I suspect that their AI, their algorithm, will probably suppress this conversation, even though it's an important topic. So if you know somebody who could benefit by having this knowledge put in front of them, please share this episode with them. Because again, as I always say, if you don't know your rights, you don't have any. Until next time, this is Justin West. Thank you for listening, and bye-bye.